Hello, my dearest friends. Svetlana Shlapak, the founder of ukvisasuccess.com is here. If you are a national or a family member of a national, you are probably quite naturally concerned about your present and future rights to remain in the UK. I have been practicing UK immigration law for over a decade now and discovered that a lot of EU nationals and their family members have only a very vague idea about their immigration rights in the UK. And to rectify this, I decided to create this special frequently asked show where I'll be answering various questions and clarifying different aspects of EU law. If you find these videos useful, please do like them, subscribe to my channel and share them with those who may benefit from them. And here is your next question. Today's training session is about accession states. This is going to be an overview video, and in my next several videos I'll concentrate on each category of accession states separately. I would like to start by explaining the term accession states. These are the European countries that joined the EU after 2004, and at the time of joining the EU, the United Kingdom placed certain conditions on their rights to work in the UK. There were three accession state waves in the United Kingdom. The first one was created by what is known the EU 8 countries in 2004, the second one in 2007 by EU 2 countries, and the last small wave was created by Croatia in 2013. Apart from Croatia, the transitional periods for EU 8 and EU 2 countries ended in 2011 and 2013. And you may ask me, Svetlana, why should I even be bothered with the rules about accession states? Well, my friends, because this is going to be very relevant when you make your permanent residence application. Because if you belong to one of the accession states but have not followed the correct rules, the correct procedure, which UK placed at that transitional period of time, will not be included for the purposes of your permanent residence application. Suppose you are a national of Poland and came to the United Kingdom in April 2010 and started working in this country. However, you did not follow the rules and have not applied for a worker registration scheme that was requested by the Home Office at that time. You were working in the UK for the next 5 years, from April 2010 until June 2015, and then you left the UK and you came back to the UK only in 2017. If you were to apply for a worker registration certificate in April 2010, you would have acquired your right to apply for permanent residence in May 2015, because you would have a proof of the fact that you were living and working in the UK for 5 years between April 2010 until May 2015. However, if you haven't applied for a worker registration scheme at that time, from April 2010, when you arrived, until 30th of April 2011, when the transitional period ended, this period of time will be disregarded for permanent residence application purposes. And in this case here, it will make a huge difference for our gentleman here, because without a worker registration scheme, he would have spent only 4 years of lawful residence in the UK, from 1st of June 2011 until June 2015, and therefore would not qualify for his permanent residence application. And his permanent residence application period will start again from 2017, when he re-entered the country. For these reasons, my friends, it is very important to understand the accession state rules, and I would encourage you to stay tuned. If you belong to any of these accession member states, please stay tuned and check out the next 3 videos where I'll be concentrating on EU 8, EU 2 and EU 1 states separately. Yes, and one important thing before you go. For all EU nationals or family members of EU nationals from one of the accession states, I decided to publish one of the sections from my free Expert Secrets guide on how to complete the 85-page permanent residence EAPR form. And it is not a random section, it is section 9b with questions about accession states. And this will be a perfect example of what I meant by knowing the rules behind the questions sections of the form, because without understanding why these questions are being asked, it is so easy to get the entire application form wrong. And that is probably why the refusal rate of the permanent residence applications is around 42%. And if you want my guide on how to complete all 19 sections of the form, you may get my free expert secrets guide at bit.ly free guide on EAPR form. The guide is recorded on a beautiful credit card size USB flash, and the offer is very limited. So don't be left behind and apply today.